Thank you for visiting the Combs-Watercutty website and our YouTube channel. We have created these statute pages to help you understand Missouri law and the possible charges you may be facing. If you have any questions, please call us for free at 314-900-HELP. This video provides details and a definition of Missouri Statute 565.030. First-degree murder trials follow special steps, especially when the death penalty is involved. Trials for first-degree murder in Missouri follow different steps depending on whether prosecutors are seeking the death penalty. The trial can be split into two parts, with separate decisions on guilt and punishment. 1. If someone is charged with first-degree murder, but the prosecutor either doesn't follow through with that charge during the trial or decides not to seek the death penalty, then the rest of the trial will be handled like any other regular criminal case. 2. If the state is seeking the death penalty, the trial has two parts. In the first part, the judge or jury decides if the person is guilty or not. Punishment is not discussed until the second part. If other charges are included, not first-degree murder, and the person is a repeat offender, the judge, not the jury, decides punishment for those other charges. 3. If the jury finds the person guilty of a lesser crime instead of first-degree murder, the case continues like a normal trial. Lawyers can argue about punishment, and the jury decides the sentence. 4. If the person is found guilty of first-degree murder and the death penalty is still on the table, a second part of the trial happens to decide punishment. This part includes evidence about why the sentence should be harsher, aggravating, or lighter, mitigating. Information about how the murder affected the victim's family. Each side can respond to the other's evidence. The jury is given instructions, and both sides make their arguments. The jury must sentence the person to life in prison, without parole, probation, or early release, instead of death, if any of the following are true. 1. The person is found to have an intellectual disability. 2. The jury doesn't find at least one specific reason for the death penalty beyond a reasonable doubt. 3. The reasons to go easier on the person outweigh the reasons to give a death sentence. 4. The jury just decides not to give the death penalty. If the jury does choose the death penalty, it must write down exactly which reasons, called aggravating circumstances, it found beyond a reasonable doubt. If the jury can't agree on punishment, the judge will sentence the person to either life without parole or death. 5. The defense and prosecution can agree ahead of time to let the judge decide if the defendant has an intellectual disability before trial, without giving up the right to have a jury consider it later. 2. 6. Intellectual disability means someone has major challenges with reasoning, learning, and daily life skills that started before age 18. It must affect things like communication, self-care, social skills, or work. 7. These trial rules apply only to crimes committed on or after August 28, 2001. Best murder and homicide lawyer in Missouri. Regardless of the degree or type of your Missouri murder or homicide charge, you will need an experienced, skilled attorney to help build your defense and minimize the impact homicide charges have on your life and freedom. The attorneys at Combs-Watercutty have a proven track record of getting the optimal outcome for their Missouri criminal defense clients. Our firm centers our clients in everything we do and works to create bespoke defense strategies that take into account the totality of their evidence and personal circumstances. Defenses against homicide charges in Missouri. Defending against homicide charges typically involves several legal strategies and defenses, depending on the specifics of the case. Your tailored defense strategy may include claiming the killing was necessary to prevent imminent harm or death to oneself or others, arguing the death was unintentional and not due to reckless actions, asserting legal insanity at the time, providing evidence of being elsewhere during the crime, believing in a situation that, if true, would have justified the act, challenging the sufficiency or legality of the prosecution's evidence, committing the act under coercion or threat, lacking understanding due to mental impairment. Criminal liability should only arise to involuntary manslaughter,